Rolling, and so we've been having a little conversation here. Anyway, welcome to our most recent and what I will certainly say is the last event we will hold this year on current issues and emerging issues in law and technology. This one is copyright fanatical, and we are delighted to have with us David Wolfson, who will be introduced by our colleague Cindy Dahl. But before that, a couple of notes. This is really the end of the year for us for 2021, but 2022 is just around the corner. Just to preview on a couple of other things. The Journal of Law and Innovation will have its annual symposium on January 28th, and we have members of the staff here, and we encourage all of you to come to talk about the symposium on innovation and crime, with more details to come. And on February 9th, in partnership with the Penn Program on Regulation, we're hosting an event on race and privacy regulation featuring our own Anita Allen, with commentary by Ezekiel Dixon-Roman from the School of Social Policy and Practice. Couple housekeeping details. This has been approved for 1.5 credits for CLE. 3 passcodes will appear on the screen at different times during the program. Those of you who would like CLE credit will need to take those down. If you have trouble, please let us know if you missed them somehow, and we will make sure they will happen. There is the first passcode. Second issue, we are recording today's event. So if anyone has concerns, please we just want to make sure everyone will know to let you know. And programs have full bios of both our moderator and our speaker, but I will defer the introductions of David to Cindy. But in the meantime, I'll just have to say we are delighted that Cindy, the director of the Dutkin Intellectual Property and Technology Legal Clinic, is here to contribute to this. She made all this possible, and she has been a tremendous force for CTIC, for Penn Carey Law, and for everything in creating what I think is probably one of the most, I don't know if I would say the most, innovative technology and IP clinic in the country that really gives students a live client experience in depth in a way that I don't know anyone else has been able to match. And without further ado, I could go on and on about your background, but since you're going to then go on about David's background, I will just pass it over to Cindy.
Thank you so much, Christopher. So should I sit or should I stand? I mean, I'll just sit. It's always a delight to be part of CTIC programming. We're always working on such cutting-edge issues, and we're indebted to you, Christopher, and the rest of the folks from the CTIC for setting up such great events. So I'm giggling. I'm so delighted to introduce you to David Wolfson. We've actually known each other in professional capacity for about 15 years now. And David is a very gifted IP litigator in the Philadelphia area. He currently is a partner at Duane Morris. He had been a partner over at Woodcock Washburn and a shareholder at Hangley Aaroncheck even before that, so he's been at this for quite some time. Personally, I know him for his great successes litigating cases that have to do with sort of like what I would say the gray areas of IP law is, basically what's confidential information, what's know-how, residual knowledge, trade secret, non-competes. But he knows everything about IP as far as I'm concerned. And the reason that we're having him here today to have this discussion is to talk about this incredibly cool case that just settled about a week ago. Is that right? Yeah. And so this is, of course, the Phillies v. Harrison-Erickson case, or as it is more colloquially known, the Phanatical case. And so let me start with some questions, but I want this emphasis to be on you. Okay, so I want to help us to set the stage. For the one person in the audience that has never met the Phanatic, can you please tell us who the Phanatic is and really what the work at issue in this case was?
Well, the Phanatic, actually, I think the Phanatic is non-binary, right? I mean, does not have a gender. Very fun fact, the Phanatic very early on did actually talk sometimes, but since I think 78, 79 has never talked. And of course the Phanatic is the mascot for the Phillies and has been since the opening day. I know it was April of 1978, I think it was April 1st. The Phanatic replaced Phil and Phyllis, who were these rather stationary and kind of stiff sort of puppets costume figures based on colonial times. So I think they had colonial dress, and so the folks at the Phillies back in '78, Bill Giles in particular, really was looking for something more fun. He was inspired by the San Diego chicken, which was somewhat profane, acquiring a lot of attention, and he thought, and he was very creative at thinking of marketing techniques for the Phillies back then, really kind of ahead of his time, and so he got the idea that they should contact Jim Henson. I think at that time, Bill was fairly young. He had little kids, and he had watched Sesame Street and knew about the Muppets and knew about Big Bird, and so he had somebody call over to Jim Henson and said, I want something kind of like Big Bird, fun, indescribable, not like a real animal.
Right.
And so Jim Henson said, well, I know just the person. She designed Miss Piggy, and her name is Bonnie Erickson. She just left my group and is off on her own. And so Bonnie Erickson's actual first design of a sports mascot was the greatest mascot of them all.
It's so pretty.
Philly Phanatic.
Yes.
I mean, do we need to show some pictures?
Yes,
I
I
got
think
tons
we
of
do.
pictures.
I think we
So
do.
Yeah.
does this, all right, I guess I do, how do I advance on here,
Should be able
guys?
to use the presenter.
This thing?
Should be.
Let me see if I can help.
All right.
Christopher doubles as an IT support.
Yeah,
He
not
does.
very well. So.
Yeah.
Yeah.
You may need some help.
Colin's coming.
Thank you, Carla.
All right, well,
Sorry, Andy.
I'll talk. So, while they're getting that up, by way of background, we'll show pictures for those of you who actually amazingly live in Philadelphia and don't know what the Fanatic looks like. Great, thank you. I
She
don't know
just
what I
has
did
the
wrong.
magic touch. That's all you needed.
So, there, of course, we're here to talk about Section 203, which is
Huh.
derivative work. So, jumping ahead a little bit, the original old Fanatic is on the left. And these were actual photos that were taken sometime around 1979, I think. We're not entirely sure. And then on the right, you see what we were calling in the case P2, Fanatic number 2. So I'll explain how that all came up. But just so you know, so there on the left is the original Fanatic, aka P1. And one of the issues in the case, you can see that they're different shape eyeballs, different color, eyebrows. Those are stylized eyebrows. Eyelashes are the stars. That's the original Fanatic.
Huh.
So
David, can I stop you there and ask
we'll
you to,
stop there.
to
Now
to
everybody
tell us
knows
a
what the
little bit-
Fanatic looks like.
Yeah, thank you. And I should tell you, the Fanatic, I met the Fanatic once, and he ate my head.
Nice.
Yes, I was.
Very polite.
Yes, exactly. He was coming to visit our softball league, and I was the commissioner, and he ate my head. Anyway, but no hard feelings.
Good. I'll let them know.
So you mentioned the reversion, right?
Right.
Which is section 203. So that's going to be very important in what we're going to
Right.
talk about today. So could you give us a little intro to that as well?
Sure. So the reversion right is, and we have some experts in different areas of the law and some law students. If anybody is aware of a provision like this, please raise your hand and let me know. Because I personally am not aware of any area of the law that says that by virtue of statute, a contract can be terminated after a certain period of time. It really is a rather extraordinary thing. Now, the contract in question was in 1984. You may remember I said Fanatic debuted in '78. Bonnie Erickson built the costume in March of '78, and Bill Giles paid her and her husband, I think, about $3,800 for non-exclusive rights to the costume. And then in '84, Bill Giles said, I'm just going to pay for all the copyright rights. And so the Phillies paid them $215,000 in 1984. So 35 years after that, you get to 2019. And in 2018, the Phillies got this notice that under Section 203, they were going to terminate the copyright. It's very odd, it's very idiosyncratic to actually, as the statute says, you can't contract around it, at least not literally. The statute actually says that notwithstanding any agreement to the contrary, the various persons, the authors and certain heirs, under certain situations, not terribly important here, have the right to terminate a contract, whether that's a license agreement or an outright purchase, an assignment. So the purpose of this provision, back in the 50s, there was a lot of lobbying by authors groups, the feeling that, this is from the House report in the 60s, but this was the basic idea, the feeling that authors were really getting shafted, not getting proper compensation, and that they would maybe sell a screenplay or a short story would be turned into a movie, or just a book made a lot of money for Random House or whoever. And at the time, they were not aware of the ultimate success that the book would have. So it was a sense of fairness and lobbying by the authors groups that there ought to be an ability to redo the contract. It really is rather amazing. I mean, I don't think there's anything else like it in the law. And for folks who are not super copyright gurus, it's like, what? They could do that?
That's crazy.
So.
Okay. So backing up a little bit, so the Phanatic is what this case is about. What was copyrighted?
That was a big issue in the case. The case is settled. The procedural posture of the case is that we tried to negotiate with Harrison and Erickson after we got the notice in 2018. Those negotiations were not successful. So the Phillies filed a declaratory judgment action up in New York asking for a declaration of various things. One of the things that we asked, and then just to fast forward, we got a decision a couple of months ago from the magistrate judge in the Southern District of New York, which was a recommendation to the actual district court judge. And because, so for at least the most important issues for the Phillies, we prevailed, and I think her logic and thoroughness were very convincing. We were able to settle the case. So that's where we're at, and that's, most of the settlement is actually public and on file and all of that. So that's where we are. Sorry, what was your question?
What was copyrighted? Is it?
Oh, yes.
2D,
So
3D?
one of the,
What?
right. So the ask for $3,800 was to design and build a costume, right? And at the time, the Phillies didn't know this was going to be successful. Almost none of the teams, very few teams had mascots. There was Mr. Matt, who I think started in the 60s. There were a couple other teams with mascots. So it was a relatively infrequent thing. So nobody was thinking that this was going to be a success. So what was copyrighted? And this gets to the interesting question of copyright in a character. So ultimately, there's the costume itself, but the first guy who put on the costume is a guy named Dave Raymond.
Right.
He was just fantastic
Temple guy,
I think he was deposed about 4 times in the case, so I really got to love Dave. And Dave Raymond really brought the costume to life. So he was the one who, figured out the shtick, or whatever you want to call it, the routines, the antics. And over the years, the Phillies developed all these kind of, set pieces, like the ATV and the, dancing on the dugout in the 7th inning.
Tug shooter.
Yeah, all hot dog, right. All these kind of things were thought of by the Phillies. And it was our view that ultimately, certainly, you know, within a few years, between Dave Raymond and other folks at the Phillies who had these ideas, there was more than a costume. There was a character. And, you know, if you read the cases in copyright about characters, a very interesting area. It's pretty amorphous. In some ways, it brings in concepts of trademark into copyright, distinctiveness, which is really a trademark concept. So we argued that there was a character and that we owned the character, that they really had nothing to do with the character. That was all disputed and never resolved in the litigation. And then we also argued that we were co-authors of the costume. So it was the costume, but that costume, first of all, Bill Giles had ideas that ended up in that costume. He and others at the Phillies reviewed sketches and gave feedback. And then obviously, if you look at, you know, the costume, it's got all of the Phillies' clothing on it, you know. So in some of the pictures, you got the hat, you got the jersey there, you've got the, jump to the end, because I've got a picture of Steve Carlton, whoops.
Oh, yeah.
And if you look at the stirrups, right? I mean, that was a Phillies design. Phanatic ends up wearing that. So, I don't know, the way I thought about it was if you just kind of looked at the Phanatic real estate, as it were, a heck of a lot of that design was the Phillies' intellectual property, including the trademark P on the hat and the star in the back and all of that. So all of that was disputed. Obviously, Harrison Erickson disagreed and said, no, we designed the costume. And Ms. Erickson even argued that she had really developed the character in the sense of something beyond the costume, the personality, the attributes in that sense. So, and actually the judge ruled against us on the character issue. I think she was incorrect. But, you know, so it was all in dispute. Was it a character? Was it a costume? If so, what about the clothing? Is the clothing copyrightable, which gets into that whole area of the law? We're talking also copyrightability back in '78 as opposed to now after Star Athletica and so forth.
Huh. Lots of great issues.
Sorry.
Cool, okay. Okay, so.
Inside baseball. It's also impossible to talk in this case without using baseball metaphors, and then you realize, oh, this is really a case about baseball, and I'm always talking about like the ballpark estimate and stuff like that.
Right. And I noticed in the opinion too that she talks about doing the 7th inning stretch, and now we're at the bottom of the 9th. You know, it's a long opinion. It's 91 pages.
You're not supposed to talk about mediations, but I don't think I'm out of school by saying that when we had the mediation with Judge Netburn, one of the things I think she wouldn't mind me saying is that she really enjoyed the case. She's a huge baseball fan. She and her husband are huge baseball fans. And she really enjoyed, you know, thinking about the issues and thinking about baseball and the mascot and the Phillies.
Well, how can you not?
Even though she's up in New York and apparently a Yankees fan, but we'll forgive her.
Well, how can you not, right? It's the Phanatic. Plus, I mean, all the issues that are in this case are fabulous. Okay, so they have a copyright registration, and it's a sculpture, right? Isn't that the category that they put this in, right?
Right. So one of the things you know you have to do is choose which particular is it a literary work, is it dramatic work, is it audiovisual work, composition. And so here, the problem was, back in '78, it was not clear that costumes were copyrightable, okay? No matter how much originality there was. So their lawyer described the Phanatic costume not as a costume, but as a sculpture, an artistic sculpture. And so we argued that that copyright registration was invalid and that therefore they couldn't sue the Phillies for copyright infringement, notwithstanding any arguable termination, because they had lied to the Copyright Office. There is a case from the Second Circuit called Whimsicality from late 80s, early 90s that basically says that, and it's where somebody described a costume as a sculpture and they say you shouldn't have done that because you kind of threw one past the Copyright Office and hoodwinked them into registering something that's not copyrightable. So that was another issue in the case.
But the judge decided registration valid, so next question.
Right.
Okay. So, what really carried the day for the Phillies?
Well, what really carried the day is this whole P2 thing. And so I'll talk a little bit
You
about
should
the
say great
statute.
lawyering.
Excuse me. What really carried the day was exceptional lawyering.
Yeah.
So, we had a lot of strong arguments on character and co-authorship, but I realized early on in the case that this termination, the exception to the termination, was definitely going to be a winner for the Phillies.
You have the statute up, right?
Yeah.
Don't you have a?
So before we get to the exception, which is called the derivative works exception, Section 203 itself, this very unique provision, says that if it's not a work made for hire, and this pretty clearly was not, where a grant of a right, that could be a license, non-exclusive or exclusive, or an outright transfer and assignment, is made after January 1, 1978, then that can be torn up, right, by the author and potentially certain heirs. And here, of course, the authors were alive. They had signed the grant. In this case, was the purchase that Bill Giles negotiated in '84, and that the Phillies paid $215,000 for. So, so that just says that you can terminate. And then we go to when that can happen. It's got to be at least 35 years, okay, after the date of the grant, up to 40. And then you have to give notice. So this is critical because you have to give at least 2 years of notice, and the notice gets registered with the Copyright Office and then becomes effective after 2 years. So you always have to think, if you're the author, you have to think a couple of years ahead of when you want to terminate, give this notice. It's a very formal thing, certain requirements in it. It actually gets filed, and you'll also send it, like a letter or an email to your grantee. Okay.
But there's some exceptions.
So now we get to the exception, and that's what won the case for us, really. Well, here's what happens, and here's the exception. So Section 203B and 203B1. So 203B says you got to give this notice, formal notice, 2 years ahead of time, and then 2 years later, magically, by operation of law, all the rights that you granted get sucked back to the author, and now the author owns everything that was granted except derivative works that were prepared not before the notice, but prepared before the effective date of termination. What does that mean? Well, that means you have 2 years to prepare a derivative work. So we prepared a derivative work. And that was P2. That's the pictures you saw before. So what is a derivative work? It's pretty clear from the statute and the legislative history that derivative work within the meaning of Section 203B1 is just the definition that appears in Section 101 of the Copyright Act. Nothing special about that. And the derivative work is based upon a pre-existing work of any type of copyrightable work. It can be an abridgment, condensation, any form in which the work is recast, transformed, or adapted. And so basically, here's one of the cases from the Second Circuit in defining it. In copyright law, one of the leading case out of the 90s on what is the minimum amount of originality that a work needs to have to be copyrightable is called Feist. It was about a phone book. And Feist said that the level of originality required is very low. That the amount can be, what was it, humble and obvious?
Crude, humble, and
Crude,
obvious.
humble, and obvious. No matter how crude, humble, and obvious, it doesn't have to be brilliant. In fact, Judge Knepper, I was disappointed that Judge Knepper did not think that the design of P2 was brilliant. She said not particularly brilliant, I think, with the words she used. But, that's not the standard. It's not like, it doesn't have to be Leonardo da Vinci. So it's a fairly low level. And so, what we did was, the Phillies were very upset, frankly, at the notion that their rights to use their mascot, that they had put a lot of blood, sweat, and tears, and certainly money, but a lot of emotional affection and nostalgia for this character that had been with them.
Part of the identity of the organization.
Part of the identity, and that was really the whole point
Yeah.
of having a mascot, is to build goodwill in the organization, an embodiment of the Phillies, as it were. In some ways, the players, obviously, every few years, they're being traded, or they get too old, or they're not very good, whatever. But the Phanatic is always there as part of the Phillies. So it was certainly upsetting to learn that this could be taken away and potentially given to another team, which seemed inconceivable. So, we came up with a strategy of developing a Phanatic P2 that would be sufficiently different from P1 that the fans would go crazy on Twitter
Yeah.
and give us a lot of grief,
Yeah.
but nonetheless would still be the Phanatic. One of the things that is hard for people to get their heads around, including a lot of judges, but Judge Knepper definitely got this, is that a derivative work is an infringing work. What do I mean by that? So, for one work to infringe another, it has to be substantially similar. We won't talk about exactly what that means, but that's pretty darn close to be vernacular, right? A derivative work is derived from another work, but don't get fooled by that word derived, okay? Because you could have a work derived from another work that is not a derivative work. What does that mean, right? Well, if the second work is so dissimilar from the first that it's, almost everything has changed. Even if you started with that, it's not going to be a derivative work, because a derivative work has to infringe the original work, which means the derivative work has to be substantially similar to the original work. So in this case, Harrison and Erickson their lawyers retained an expert who said, well, he looks like the Phanatic. P2 looks like the Phanatic. Everybody, if you're sitting up in the bleachers, you'd hardly even notice the difference. And we said, so what? Of course it's the Phanatic. It wouldn't be a derivative work unless you recognize it as the Phanatic. It's got to be substantially similar. But this is a little counterintuitive to people, and the word derived gets thrown around a lot. So just to give a little example, if I wrote a short story, if I am a filmmaker, okay, and I take a short story by Edgar Allan Poe. Now it's in the public domain, but let's pretend, Edgar Allan Poe's great-great-grandson or something is writing great horror stories, and I take that, and I write it out longhand. I copy it. I copy the whole thing. But then I start changing, and I end up with a treatment for a film, and then I make that film. And when you look at the two things, it's like, yeah, there's a couple of little similarities, but it's not substantially similar. So my film is not a derivative work of Edgar Allan Poe's great-great-grandson's work.
So take us into the room where you were you part of this discussion about how to create this derivative work and what to do and how to change the Fanatic in just enough, but not too much?
Well, I don't want to give away anything confidential, even though the case is settled. But Dave Raymond came back, and he was retained by the Phillies, and then there were folks at the Phillies, creative people or people who just loved the Fanatic. Everybody kind of sat around in the room. I mostly was not there. And they threw around ideas. What if we changed this? What if we changed that? I don't really like this anyway. How about if we went with, some of these other things? And they had a lot of fun with just reimagining the Fanatic. And then my role was just really giving advice about complying with the law, right? So in that sense, I had to say, yeah, I think this is enough, or I don't think it is enough. Go back and think about what all can be changed. Because on the one hand, it's going to be it's a weird paradox, right? Substantially similar. You're going to recognize him as the Fanatic. He's certainly recognizable as the Fanatic. But you've got to come up with some creative things. And the more you can do that, the more creative, the more changes in terms of colors and shapes and overall goofy ideas and stuff like that. Like the Judge Netburn loved the fact that the P2 has a duck butt, P1, he's got a big butt, but it's not really a duck butt.
We should get the pictures back up.
We should get the pictures back up. So I don't remember whose idea that was. It was very much a group kind of thing. So there's the P1, the original Fanatic, it's got a kind of a steeper angle, right? And P2 on the right, it's sticking out more, and it definitely is inspired by Donald Duck. So Judge Netburn thought that was hilarious, that she was writing an opinion. She never thought she'd use the words duck butt in an opinion in the Southern District of New York, very august court. So needless to say, this was fun. The shoes, for example, they had changed over the years anyway. One of the interesting issues in the case, never really resolved, is for purposes of the comparison, what do you compare, right? So, on the right, we have the new Fanatic. On the left, we have the old Fanatic. These happen to be pictures taken in '79. Do you compare the new Fanatic with '79? Or do you compare the new Fanatic with him the way he looked 3 or 4 years ago?
Or just before they served the notice?
Or just before they served the notice. These are difficult issues that were never really grappled with or resolved in the case. And how about all the 2D? You guys, most of you probably been to the ballpark. There's the climbing wall, which is, it's really kind of two-dimensional. It's got 3 dimensions, but I guess you call it like a bas relief or something, but it's flat. You've seen innumerable depictions of the Fanatic on T-shirts and caps, and some of the really fun merchandise that they've done. One of my favorites is like the Game of Thrones where he's sitting. It says House Phillies, and he's there. That my favorite. There's the dangle hats, some of the hats, which if you didn't really know the Fanatic and you just were coming from outer space or maybe even New York, you wouldn't necessarily even think is the Fanatic. So do you compare it with that? Or do you compare him only with the costume, not with the art? That was there is no case law that really helped us with that decision.
So you mentioned something that was really interesting that I wanted to go back to again. So you said that basically as long as you've created the derivative work, by the time that the termination kicks in, you're okay. So why wouldn't everybody just create a derivative work after they get a notice? Like, why do we have a reversion right that ever, as any sort of enforcement?
Well, first of all, not all copyright is about mascots. If it's about the big issue that was discussed by Congress in going through a number of drafts on the derivative work and by the assistant registrar, Barbara Ringer at the time, they were really thinking about movies, or as they called it back then, motion pictures. So the motion picture industry was very concerned about this provision. They put, tens, hundreds of millions of dollars into a movie based maybe on some character or a short story or a screenplay, and now the rights were going to revert. And now what? They couldn't show the movie again? And I think they argued with some justification, and Congress then, this is what we have as a compromise. They said, look, we're not denigrating what that author did, but there's a lot more to a movie than just the plot. For one thing, we changed the plot a lot. We changed the story. And then there's directing. Are you ignoring that? There's acting. There's music. All of that, none of which is in the screenplay or the novel or the story. Some of it may be suggested, 80% of it may be very different. So they said, look, we got to have an exception for, in effect, sort of vested rights. Now, if you got a notice and you're MGM, you probably couldn't crank out another movie in those 2 years. I don't think. This 2-year notice, it's not discussed at all in the legislative history, but it's not, I'm not taking credit as a brilliant lawyer for just reading the statute. You read the statute and it says a derivative work prepared, just the word prepared, doesn't have to be publicly released, doesn't have to be sold, just uses the word prepared before the effective date of termination. Congress easily could have said before the notice is sent. Now, to your question, does this totally undermine the intent? I don't think it undermines the intent. Because if the Phillies had lost every one of these other issues, and that's not clear that we would have, co-authorship, the character, the fraud on the Copyright Office, even if we lost all that, but if we lost all that and we used P2, we still would be precluded from using P1. So, some people like P1 better than P2. Some people like P2 better than P1, whatever. But it's not like rights were not reverting to Harris and Erickson. But really the big takeaway for me is you have a statute with good intentions to help authors who got, didn't really get a fair percentage or royalty or whatever out of something that ended up making other folks a ton of money. That's certainly a good intention. Let's try to level the playing field. It's a statute of general application. It applies to every kind of copyright. This is, I guess, before Mr. Met, so I don't think there were any mascots, but in any event, obviously Congress is not thinking about mascots. This is an example of a case where a law of general application really doesn't work here, right? If I'm selling you the design for a costume, that is now going to be the centerpiece, one of the main, linchpins to your marketing efforts and your desire to build a brand, and you're going to put millions and millions of dollars into it over decades, it doesn't really make sense that that can terminate. So on the one hand, I would just say that statute really shouldn't have any application here. Based on the plain language, I guess it does. But let's look at the plain language, which also allows the Phillies to do something that at least saves the fanatic, even if he looks a little different, and be able to go forward and retain some of that goodwill that they brought to that costume. Whether that's Dave Raymond, whether that's paying, Dave Raymond and all the other performers over the years. It was 40 years of salaries for these folks, as well as the staff at the Phillies that help, and the charity engagements. He does like 200 a year for free. That's a huge investment by the Phillies, and for that to just get sucked back by the authors, I don't think in this situation would have been a fair result.
Well, the licensee takes all the risk, right? Because
Exactly.
the licensee, if it doesn't amount to anything, then the original artist doesn't ask for it back. If it amounts to a whole bunch, then they've invested and they lose
Right.
everything. So they
Yeah.
take all the risk. It
Doesn't seem fair.
right, yeah. So we talk about trademark and copyright and the interplay, because part of the value of the Fanatic is the brand, right? And the Phillies have obviously spent a lot of money building up the brand. So if Erickson Harrison had gotten it back, if we couldn't use the Fanatic at all anymore, then could they have used the Fanatic?
Yeah, I don't think so. And so if we look at
What was the question? Would they have used it?
Could they have?
could they
used
have,
it?
what would they have used it for? So if you look at I'll go back to some of these. So 203B5, termination of the grant, so this is the reversion, right? Affects only the rights covered by the grant under this title, meaning a copyright right, a license for a copyright or an assignment of a copyright. This was an assignment of copyright. In no way affects any other rights. So that would be trademark. And the Phillies, so here's an example of a two-dimensional representation of the old Fanatic, right? And that was done by Bonnie Erickson. So she drew that for the Phillies. They paid her a few grand just to do that rendition. And then the Phillies took that and they went to the trademark office and they got a trademark on that. So it's literally the Fanatic, the word Fanatic is a trademark. And the design of the Fanatic, as we see it here, is a trademark, and it's been around for many years since the registration, so it's even an incontestable trademark. So again, Congress is not thinking about this at the time, right? They're thinking about musical compositions, not anything that typically you'd be building a brand around, right? Or they're thinking about novels or short stories, again, not something that you typically build a brand around. And if you think about reversion and termination of those kind of things, it's fairly straightforward to negotiate. If you're a record company or motion picture industry, you're dealing with one song, maybe one record album, one story, and it's not going to be the end of the world typically if you say, no, you're asking too much, I'm not going to do a deal. So here on the one hand, the Phillies need to keep its trademark. On the other hand, we just saw the section 203 that says this doesn't affect trademark rights. So the whole thing gives you a headache, right? Because what exactly would be reverting to them? Well, the copyright rights. Okay, to answer your question, anybody who goes out, even though Bonnie Erickson presumably now owns that design, you know, if she had won this design, the Phillies own the trademark, and the statute says it doesn't affect trademark. So certainly at a minimum, what that means is that Harris and Erickson couldn't have sold anything that would be recognizable as the Phaнаtic to anybody else, because certainly in the United States, there would be likelihood of confusion. They'd be violating the Lanham Act. So this is a very odd situation. I think one of the reasons it's settled is it's not like they could go to, you know, another movie producer and say, well, how about you? Would you like to buy it? Or another record company and say, I got this great song, you know, this Beyonce song or something. They won't pay me, but how about $5 million? They couldn't do that. Nobody would pay good money for the Phaнаtic knowing that they would be sued by the Phillies for trademark infringement. So a very odd situation. What would have happened, though, if the Phillies are not allowed to use that guy there, right? They can use it as a trademark. Would the court maybe have said, okay, pay a royalty, you know? I suppose that's one possibility. Certainly, and I'm sure this is one of the things that, you know, settled the case, in terms of an injunction, that was never going to happen. How could the court enjoin the Phillies from using its trademark because of reversion of copyright when the copyright law says this doesn't affect trademarks? Because any injunction against using the Phaнаtic would be enjoining our use of trademark rights. So that's one of the things that made this situation very unique and odd.
I just wanted to switch, so we have another
Oh.
silly word.
Oh, good. City.
Yeah. I've got one more question, and then I want to open it up to the audience, because I'm sure there are a ton of questions. And I think that Carlin is also gathering questions from folks that are attending virtually too, so she can also relay
Okay.
those to us as well. So my last question, at least for now, is what can you tell us about the settlement? I've heard that we can now use P1, and so we're back to that, but how did this all settle, and what are our rights now?
Oh, you know, obviously we got a good ruling from Judge Nepern on this whole derivative works exception, and mixed ruling on the other issues, but the derivative works was going to let us go forward and use the new design, which a lot of folks really liked. Some folks didn't like it, but clearly if we could go ahead and use that design, then Harris and Erickson weren't going to get any money out of this. Now, I will say that one of the issues that Judge Nepern didn't decide is the derivative works exception says that a derivative work prepared before the effective date of termination may continue to be utilized. Continue to be utilized. And there's not a lot of law about what that means, much less in a Mascot context. So we argued that, look, the deal that Bill Giles made in '84 gave us all the rights to a mascot. And what do you do with a mascot? You know, you take pictures of him. Nowadays, obviously social media, he's got a Twitter account, he's got an Instagram account. There's the kids' coloring books. There's the Fanavision in the ballpark. There's movies, there's videos, books, and so forth and so on. So that's utilization of a mascot. Again, kind of gets back to the meta theme that a mascot is something that you build goodwill, a team's goodwill around, becomes a symbol of the team, a repository of all the good vibes of the team, and a kind of embodiment of that team spirit, right? And in order for a mascot to have that quality, you've got to utilize him in all those ways. So we would say continue to utilize means all of that. We're going to continue to use him the way we've been using him. That issue was never really decided, and it's one of the reasons, frankly, that ambiguity of the case law is that, we settled the case because it was not 100% clear how that would come out. I mean, I think we had the better argument. They argued that every time we sat the fanatic down to pose in some new costume on his Instagram account, that photograph was itself a derivative work, and that we couldn't do that. Everybody's puzzled, so if we go back to, okay, this guy's not working. I'll read from the statute. It's always good to have things in analog. So 203B1 says that, that's okay, no big deal. A derivative work prepared under authority of the grant before termination may continue to be utilized, but this privilege does not extend to the preparation after termination of other derivative works based on the copyrighted work. What does that mean? Not entirely clear, okay? Just give you some examples. So, and this is really interesting in terms of the meaning and the purpose of this termination right. The idea was that the artist or the author that was not fairly and adequately compensated at the front end should be fairly and adequately compensated after 35 years, given the commercial success of that particular work. And that's based on what that person provided, whether it's the plot or whether it's the music, right? This says that you can't make a derivative of a derivative after termination. But let's say the Phillies took Bonnie Erickson's design, but didn't change anything about that design. But take that costume, and they designed a new outfit, and put that outfit on the Phanatical. That outfit, by definition in my hypothetical, was the Phillies' content. Are they allowed to do that? Is that a derivative work based on what Bonnie drew or what Bonnie designed? We would argue no. And similarly, with the Instagram, if the Phillies are paying for the Fanatic to appear, and they're paying for a photographer on staff or work for hire or whatever to take a nice photo, and they're putting it up on Instagram and incurring that expense, we would say that's the Phillies' content. We're not redoing what Bonnie Erickson designed, so it's not a derivative. But that was one of the issues. There's only one case that I have found on this issue. One case from one of the districts in Texas called Arquitectura that says, you know what, you're allowed to contribute your own content after termination as long as that's really your content and you're not redoing what the original artist said. But that's only one court, and also David Nimmer, who's the leading commentator, says, yeah, I think that kind of makes sense. But that's all kind of up in the air. So that's going to be for the next case. In terms of the settlement, you asked, so what was the deal? Some of it's confidential, but there's filings in the Southern District. The Phillies got all rights to the Fanatic back. So they're allowed to use the original costume. They're also allowed to use the P2 and the new costume in every medium, every way, shape, and form. And Harris and Erickson no longer own anything.
So now it really is forever.
It really is forever, which would be for the life of the authors plus 70 years under the copyright.
Terrific. Can we open it up to questions? Great. Alex?
I have a question about, you said you can't waive this right, sort of it's inalienable, sort of, and how would you recommend transactional attorneys sort of insulate their clients from this issue if they know it's likely going to be a problem?
There's a great chapter in Nimmer about, there's very little case law on this. I think actually most of the case law is about the similar section 304, which is about the renewal term. And a lot of the provisions in 304 are almost exactly the same, or exactly the same as 203. So there's very little case law. And Nimmer poses a number of hypotheticals, and I would read those. There's certainly, I will say, we made the argument, and it certainly got legs, and I think it has some intuitive appeal. So the statute says, notwithstanding any agreement to the contrary, the author and the heirs can terminate. Agreement to the contrary. So we argued agreement to the contrary is an agreement that says you can't terminate, right? But other kinds of agreements are okay. And we said, look, when we paid you guys $215,000 in 1984, we got an assignment. It had the word forever in it. That certainly meant at least for the life of the copyright, you weren't going to sue us. And you know, when we paid you that money, the expectation was that was it, forever. That's what forever means. So we didn't get that. We only got 35 years as opposed to, 80, 90, 100 years, which is what we were expecting. So under an unjust enrichment theory, you should give us back pro rata, approximately 2/3 of the value that we didn't get, to say nothing of how expensive it is to litigate the case and deal with the distraction and annoyance of litigation. Judge Netburn said that she denied them summary judgment, and so that claim was going to go forward. There's not a lot of case law about like that kind of thing. So there's certainly room for creative thought here, but you're not going to be able to tell your client it's a slam dunk until you have a Second or Third Circuit case on point with a certiorari denied, I guess. Or maybe something from the Supreme Court.
Can I jump in? If this were work for hire, isn't that an out?
Yes, but you can't always do work for hire. Yeah. No, absolutely, that's a great point. Work for hire, you can't terminate for work for hire.
Which is defined as work for hire.
Work for hire it's a long definition, and there's sort of two branches. One is an employee. An employee is a term of art that has a lot of case law. The creative nonviolence case from the DC Circuit is still kind of a leading case on that. That's from the late 80s, early 90s. On what is an employee. And by the way, there's also different definitions if you're talking about the 1909 Act, which is the act before this. What we're talking about here is the 1976 Act, so be careful about that. And then there's for certain kinds of works, but it's a laundry list, and it's a limited laundry list of the types of works that potentially can be work for hire. And there the courts are very strict in saying that it really has to say, this is a work for hire, dude. You're really giving me everything. But that is only for certain kinds of work. So the whole work for hire thing is complicated, but you're right. Depending on what type of copyright you're talking about, that could be an option for clients.
Carla.
Okay, I have a couple. The first one is, with regard to the merchandising question, what does the settlement allow with regard to that? What do you think Section 203 would allow? Could you sell stuffed Phanatical dolls, posters, T-shirts?
So in the terms of the settlement, the Phillies have all the rights back, so they can do whatever they want in terms of merchandise. So that's easy. If the case hadn't settled, and let's say we lost all these arguments except the P2 argument, then it would have been a problem in terms of the merchandise, because to the extent that the merchandise is recognizable as a Phanatic, and there's really no point to it unless it is, right? then I would argue you're gonna have a trademark violation. So what would have happened, it's not entirely clear. You know, I spent a lot of time thinking about what the potential remedies were, because you're in this weird situation where theoretically Harris and Erickson are getting reversions of rights, but they can't do anything with it, right? Which actually is why the case settled, okay? But put that aside. So they're getting a reversion because of the trademark. They can't sell it to anybody else. They can't monetize it. They can't go out and say, get your Phanatical dolls here, right? Would a court have potentially imposed some kind of royalty? Maybe, you know, because an injunction, as I said before, I don't think was a viable option. They never asked for a preliminary injunction. I think they saw it the same way I did. So potentially, maybe the Phillies would have been required to pay a percentage on the P1 merchandise, but Judge Netburn seemed pretty clear that as to P2 merchandise, which, you know, presumably that would have been the focus of the Phillies anyway. It's like, okay, we can't settle the case, we're not gonna use P1, we'll go with P2, and then we'll sell P2 merchandise, and we don't even have to pay them a royalty. Now you get into the derivatives of derivatives. Let's say that before June 15th of 2020, which was the termination date, we had never done some kind of a t-shirt that showed P2 in some funny position. And now after June 15th of 2020, you know, our merchandise group or one of our licensees or one of the licensees of Major League Baseball comes up with some really creative, fun, new depiction of the Phanatic. Is that a derivative of a derivative, which is barred by the derivative works exception? Again, that will be for another case to answer, because that issue was not answered in our litigation. But right now, the Phillies can do whatever they want.
I mean, the goal of them filing a notice of termination was to basically extort, I mean, I hate to use the word extort, but to get the Phillies to pay them a lot of money. I mean, is that right?
Well, I want to be fair here. So, look, you know, we're all lawyers, right? You read the statute, and on the one hand, I say the statute clearly says we can make a derivative work after we get the notice of termination and before the date, and that's fair because that's in the statute. On the other hand, they clearly have this right of termination. How valuable it is, all the things I've been saying here today.
What's your motivation, though, to exercise
But
it?
your motivation would be, I have this right, and you should pay me more money. Now, you know, look, I represent the Phillies. I've been working on this case for 3 years. I'm totally biased. My feeling was this is not a case of the type that Congress was thinking about. Why? Because as I mentioned, Phanatical was already wildly popular in '79. And in '79, there was first litigation. They got paid around $115,000 to settle that. And then in '84, Bill Giles paid $215,000, which is about $600,000 in today's money. So not insubstantial. And this was for a costume that, it's a great costume, but you know, it took 10 days, and Bonnie Erickson, you know, paid a bunch of people to help her make the costume.
And there was a back and forth and a collaboration, and
There
then
was collaboration, and Bonnie got paid for all, just the one that we're seeing right there. You know, got every time the Phillies said, hey, can you do him in the at-bat or with the star or whatever, she got paid for her work nicely. So this really wasn't the kind of situation that cried out for some injustice. On the other hand, look, under the plain language of the statute, they had the right to do what they did.
But you could see other forms, other works where the reversion right would have independent value, unlike here.
Absolutely. Musical composition or a recording, of course. Easily, by definition, it's very successful, and so it's easily monetizable. And there's probably not going to be any trademark issues or other areas of the law that it butts up against that lessen it. But, you know, the lesson here is, look, if you sell somebody a design for something that they're going to build all this team around, and that's going to be literally a trademark, but even if it weren't literally a trademark, that's goodwill, you know, you're going to have problems with determination and exactly how much goes back and what kind of relief a court is going to be willing to do. Because courts of equity, in terms of the injunction, you know, had they been able to get an injunction, that would be, you know, a big deal, right? But they never even asked for an injunction. And that's because court of equity has to consider all those kind of things. But that wouldn't be the case with a musical composition. You know, why does Sony absolutely have to sell, you know, Beyonce's latest song or Adele's latest song? They don't have to. Maybe they'd like to, right?
Carlin, I know you have a few more.
Yeah, you'll have to correct me if this is the wrong word, but has the unjust encroachment question been litigated before? Also, on policy, if you enter a contract that says forever in a legal environment where such contracts are not enforceable due to fairly clear language from Congress, it seems like you are assuming the risk.
The last point is, the first one is unjust enrichment. So you're assuming the risk, yeah, assuming everybody was thinking that at the time. Certainly the statute was out there. I know that Bonnie Erickson, because she testified at the deposition, that she was not aware of the statute and that her intent was that the Phillies could have it forever. So, but that's a fair point. The unjust enrichment theory, I don't think has been litigated before. I'm not 100% sure, but I think that was something that we thought, well, okay, you can terminate, but we haven't gotten the full value, and you even intended to give us forever. So how about you give back some money? And it made intuitive sense, and now we won't know until somebody else raises it.
Go ahead, Carlin.
So the questioner is saying, I'm a bit puzzled and intrigued by the claim that trademark provides affirmative rights that would prevent the use of a copyrighted work. Are you suggesting that this is true in the absence of a showing of infringement or dilution?
Oh no, you would have to show infringement. It doesn't just sit out there. But my feeling was that you'd have a pretty clear case of infringement. I mean, let's put it this way. If Bonnie Erickson went out and sold something that was not recognizable as the Phanatical, but was a cute stuffed animal, probably the Phillies wouldn't care, right? But as soon as she sells something that the ordinary person or the consumer in that market for those kinds of goods would say, that's the Phanatical, the source must be the Phillies or a licensee, that would be probably a trademark violation. So that's all I meant.
But it's a great example of the death of election. You know, the fact that the rights are now cumulative and clearly cumulative, unlike what we used to think. And so, I mean, just each of them are standalone claims, and that just allows you to analyze it in a nice, clean way without having to deal with them bumping up against each other as they often do. It makes total sense.
Yeah, and there is a line of cases, the name is escaping me right now, but there's a line of cases that actually talks about the intersection of copyright. I'm not talking about Daystar, but more on the infringement to get to that questioner's point of view. I just can't remember that line of cases, a leading case, I think from the Second Circuit, maybe it's from the Ninth, about when something's both copyrightable and trademark and what the standards are. And there's a requirement of actually a higher standard for infringement in that case. And then there's also an interesting case that's kind of reminds me of this, of the American Airlines logo, where the Copyright Office actually rejected and said, well, that's really a trademark and there's not really enough originality. And then the court didn't follow the Copyright Office and said, no, you know, just because it's trademark, it's a really nice logo. It's got subtle shading and use of color and overall design, and it's not just some copy of some known element or geometric shape or whatever. So, you know, there are some cases that kind of start to address this, but I'm not aware of any in the Section 203 context. So that was kind of unique here.
What's to stop a music publisher from preparing a derivative version of each song whose writer is seeking reversion?
I don't think anything. Now, then you're going to get into the derivative of the derivative problem that we talked about. But as to that derivative work, I think under my reading of the statute, you'd be able to do that. You got 2 years, and that's a good point because, yeah, you probably could bang out a number of them.
But the composition would have to be sufficiently different to really be a true derivative work. Because the performance will be different, fine. That's Taylor Swift all over the place, right?
Right, I was gonna ask about her and.
But you'd have to actually have a work that is sufficiently distinct, but be commercially similar enough to generate the same revenue. You'd have to walk a very fine line if you wanted to do a derivative work to avoid the reversion on the composition side. Is that right?
So there's two aspects of music copyright. There's composition, and then there's the recording, right? I think we're talking about composition. So let's put it this way. It would have to be as different as P2 is to P1.
Maybe new standard.
At least for Judge Netburn.
It's kind of interesting to think about a derivative work of a composition, though.
Yeah.
You know, that to your point that some of these rules line up better with certain kinds of creative works than with others. You know, I can't think about a derivative work. Maybe the questioner was asking about recording, re-recording, which is a whole different thing.
Well, re-recording, you're not using the recording, so you're not infringing the recording. You're doing a new performance. The performance per se isn't copyrightable. The new recording is you've used the musical composition, so potentially you're infringing the composition. But yeah, I mean, that's a good point.
Okay, query whether a mascot should be eligible for copyright protection as a character. A mascot isn't a character like one in a book or movie. If a mascot weren't eligible for copyright as a character, this case would arguably just turn on the trademark issue. Possibly more of a comment.
I didn't follow the last sentence, but in terms of the character, that was a really interesting issue in the case. And this whole area of character sort of separate from the underlying work is fascinating and not super well developed. The Ninth Circuit has most of the cases on it because it's out of the motion picture industry. There's a recent case involving the Moodsters that says that the figures were too generic. And then it cites as good law the Towle case, T-O-W-L-E, which did find copyrightable as a character the Batmobile. The really interesting thing about the Batmobile case is that the court went out of its way to say that the Batmobile could be, you could be infringing the Batmobile by copying the attributes of the Batmobile, and that the Batmobile was a character, even though in the actual works, the movies, the car itself looked different. Because they would do these Batman movies every few years, and I guess, I haven't seen all of them, but I guess, they would update the car, right? But that the car had certain personality attributes that were consistent and distinctive, which is a trademark concept, not a copyright concept, but sufficiently delineated to not be like Saint Affair or just sort of these, ideas sufficiently detailed that they weren't at a high level of abstraction. And so we argued, and I think we were right, Judge Knepper disagreed, but we argued the Phaнаtic, of course, has a character. And, consistent attributes, personality. Also, one of the things, this is funny, this is trademark, folding into copyright, the Towel case says, and one of the things that makes the Batmobile as a character copyrightable is the consistent use of the name, Batmobile. Now, the Phaнаtic, that was the Phillies' name. I forget who exactly the Phillies came up with it, but that was not a Bonnie and Erickson thing. They came up with the PH and all that, So we have the Phaнаtic. We have the character, the personality created by Dave Raymond originally, and then all the shticks that have been consistent over the last 40 years. Hot dog gun, ATV, the kind of racing around, the kind of dance, the sticking out the butt and all the kind of Tommy Lasorda, whatever. Those things they're in. So let's just go back to basics. To be copyrightable, the work has to be fixed in a tangible medium of expression. So this is where you start getting into some weird stuff about the character, because are we saying that you can infringe a character that's fixed in a lot of different mediums of, a lot of different movies, okay? So a movie that's recorded, it's stored digitally now, it's fixed in a tangible medium of expression. Okay, great. But what if the character is different in movie A, B, C, D, E? The Towel case even says, oh, that's okay in terms of physical appearance of the car. Well, that's kind of weird. It's a little hard to get your head around it. Like, how does that work? Because if it's got to be fixed in a tangible medium of expression, but you're not necessarily infringing work A, B, C, or D because it varies, but you're kind of infringing the conglomerate of those and these sort of character attributes that you're taking out of those 4 or 5 movies. But now you're kind of infringing something that actually isn't fixed in one medium of expression. So this is the paradox, but the cases like Towel have striven to find copyrightability, even though you can't go register a character in this sense. You could register the character like what we see up on the screen and say, but that's a
PSG.
yeah, pictorial, but not like a character. You can't register a character with the Copyright Office, yet character can be copyrightable. I think, to me, Phaнаtic, you got the name, many years, many things fixed in a tangible medium of expression, consistent personality, attributes, whatever you want to call it, should be copyrightable as a copyright character.
You said the Phaнаtic was one of the first baseball mascots. Do you think there's going to be more of these lawsuits, maybe as people's reversion rights start coming up or termination rights, or do you think your guys' case is going to be sort of
I have no idea.
Okay.
Yeah, I mean, it depends on, maybe there's, some of them will work for hire. Mr. Met is pretty old. I think he's like 63, 62. So, I don't know.
Yeah, and how much of a brand, potentially someone they've built around, an organization's built around the.
A lot of, and actually, it's really, one of the fun things about the case was just delving into, spending a lot of time looking at the other mascots and which one became successful. And clearly, the Phanatical was the most, although now we've got Gritty. I mean, we're quite the mascot town, right? And Gritty is amazing. But Bonnie Erickson designed a mascot for George Steinbrenner, well, for the Yankees. George Steinbrenner hated it, and it only lasted, I think, a few games, and then they pulled the plug on. He was a guy with like a handlebar mustache, and so a lot of them just never really got traction for a variety of reasons. Probably not having to do with their intrinsic, aesthetics or the funness of their appeal. I mean, you look at these different mascots there, maybe you like them, maybe you don't. I don't know exactly why the Phanatic has been so successful, but one reason clearly is that the Phillies have been consistent in promoting him, and he's had great performers in the costume.
Phenomenal
Yes.
performers.
So now that you mentioned Gritty, I think I want to get a look at that contract and see what they're doing with the reversion rights.
Well, they got a good 30 years anyway.
That's true, that's true.
Carla, are there any more questions online?
Any more questions?
Then
Okay,
I'm going to
great.
burn the light. Come on here, David. So I have to admit, when you talk about the Batmobile case, I'm not as skeptical. And I'll give you the first example that popped in my head was James Bond. And the
Yeah.
second example is Doctor Who.
Right.
Or Ghostbusters with the women. We're now repurposing all these characters through different characterizations. I mean, different, visual representations. But you would still have copyright in the character, even though it's been fixed. Doctor Who's gone through how many iterations? It's still a character.
Right. Where you get into a difficult issue is where maybe the character isn't fully formed in movie number 1. Nimmer talks about, well, what happens with Sherlock Holmes where some of the short stories go into the public domain and some of them are not. So by definition, if something's in the public domain, it's been dedicated to the public, you're allowed to use it. So I'm allowed to pick up those early stories and do a Sherlock Holmes character. And then the estate says, not so fast, you're infringing the later ones, they're not in the public domain.
So then do you have to go back factually and look at, like, when did he develop the hat and when did
Exactly.
he develop the pipe and...
I think that doesn't come up that often because, like James Bond, I don't remember what the very first one was, but that character was fully formed because Ian Fleming, it was based on the book, so maybe it doesn't come up as much. But theoretically, it seems like even though copyright has to be fixed in a tangible medium of expression, you could have something that is overarching and developed over several different works, and the person that infringes the character may not be infringing, theoretically, any one work. And that's just an odd I'm not being skeptical. I mean, I agree that there probably should be protection, but it's an odd concept to get your head around because so much of what we deal with in these infringement cases is, you're comparing this thing, which you probably registered with the office, or the office rejected it, but at least you have the application. So I know what it is, and then you're saying I'm doing this. Okay, let's compare what I'm doing to what you are saying you have a copyright.
David, I could talk to you about this all day long.
All right.
but Thank you so much for coming.
Sure,
and-
very well.
Do you have anything that we need to close out with
I
the
don't think so.
CLE?
Did we get the third word up, Carla?
Yes.
We did. All right.
Excellent. Thank you all
Thank you
for
all.
coming and for asking such great questions. And thank you, David.
Okay.
I don't think you have to take it down. I think they're going to help.
This is awesome.
Oh, good, thanks.
We have a pretty good crowd online. This is the way things are these
Great.
days.
Yeah, I
There's
know.
online options.
Good. Thank you. Boy, you had a lot of questions.
Well, she was
Well,
representing.
was-
I know, I'm
Yeah.